2 o'clock docket, and I'm going to call first the matter of Whitley versus Castle Key. Have I got counsel for the plaintiff on that?
Yep. John Bernstein.
Yep.
Yes, Your Honor.
Oh, there we go. Welcome to the courtroom, Mr. Bernstein. All right, Mr. Bernstein for plaintiff and for Castle Key.
Yes, Your Honor. Jeffrey Best on behalf of the defendant, Castle Key.
Okay, Mr. Best, good afternoon to you as well.
Thank you.
This seems unworthy of a hearing. We need to change one word in the party name. Why are we having a hearing, Mr. Best?
Well, obviously I filed a motion to dismiss because Castle Key Insurance Company is the named defendant, and they did not write a policy of insurance. It was Castle Key Indemnity Company.
Right. Okay,
and I understand it's one word, and plaintiff filed a motion to amend the pleadings by interlineation, but
right.
How can we do that without the properly named party being properly served? I'm not authorized to accept service for Castle Key.
I got you. I guess I just thought that perhaps the parties would speak. There'd be an agreed order to amend by interlineation, and then giving defendant, 20 days thereafter to respond. That's usually what I see on these.
That we had a discussion, but it didn't get to that extent.
Okay.
I mean, quite frankly, this happens a lot of times with Castle Key cases I'm on, and quite frankly, the plaintiffs just amend the complaint and serve a new one, and we don't even have to have a hearing. But
right.
I don't have a problem entering an order, granting them leave to amend the complaint, but it's got to be served on the proper party, and I cannot accept service.
Okay.
And I think that was the big hang up because, I'm not the corporate, the corporate representative authorized to accept service. So,
okay.
So there's that.
Mr.
And then also,
go ahead.
I just want to make sure that, as far as any discovery directed toward Castle Key Insurance Company, that does not need to be responded to, as they're really not the properly named party.
Okay. Mr. Bernstein, your thoughts on that?
Yes, Your Honor. Well, here's the problem. And we, candidly, it seems that there's two insurance companies, Castle Key Insurance Company, Castle Key Indemnity Company. Now, they both have the same address. They both have the same registered agent. They both have the same corporate hierarchy, according to Sunbiz. When I did sue, and admittedly, Castle Key Indemnity Company seems to be the right insurance company. Now, when I sued Castle Key Insurance Company and I served them, what happened was their attorney, Mr. Best, appeared in this case, and he also wrote us a letter demanding appraisal for the insurance claim.
It's on mute.
I'm sorry?
I think someone else was speaking.
Oh, okay. So now this is a covered claim that they've demanded appraisal on. And now we're and we agreed to appraisal. And now, actually, in all actuality, the case is going to end quickly, and then we would move for our attorney's fees based on being the prevailing party, assuming we get a substantial appraisal award worthy of fees.
Okay.
The problem is that if we have to reserve a different insurance company and bring them into the case now, they would have already demanded appraisal. It's all moot. So it seems like we should just be the right insurance company did get served and hire the attorney who then did their request for appraisal. So I do believe interlineation is fair because they got served, they analyzed it. It's all the same people analyzing the thing. And I feel like it's only fair. And we did try to resolve this pre-suit, and they didn't want to. They get served, now they demand appraisal. So it just seems fair that they now have to live with a lawsuit that they know about, that they have the same attorney for both. So Castle Key Insurance Company got served, hired Mr. Best, who then wrote us a letter saying he represents Castle Key Indemnity Company, and he's demanding appraisal. And he also writes a pleading, in this case, moving to dismiss for Castle Key Insurance Company. So we believe it is fair just to amend by interlineation. The insurance company was aware of the suit. The building got served with the case. They know, all the parties know what's going on, and it would be okay to amend by interlineation.
Okay, Mr. Best, do you want to respond to that?
Well, I mean, again, the civil rules of procedure have been in existence for a long time, and again, I am not the agent for Castle Key Insurance Company. They are not. Castle Key Indemnity Company, the company that demanded appraisal, is not a party to this action. So to just allow a pleading to be amended by interlineation without having to be served upon the proper party, I don't think complies with the rules of civil procedure. I mean, I understand the position. Well, it's the same people, it's the same, registered agent. Well, that was true every time you served, CT Corporation system. Theoretically, every corporation in the state of Florida has been put on notice. The point is, Castle Key Indemnity Company needs to be properly served. That's all.
I guess the only hesitation I have, because certainly I want to follow the rules, but if you, Mr. Best, took affirmative action on behalf of Castle Key Indemnity as a result of having been served, then that's the one sort of a weak point in the argument, because otherwise I think I would be, it seems inefficient, but I would be, I think, constrained by the rules to say, you got to go reserve because you got to have the correct party. But if we have a very thin veil between the two parties, I still would probably make them go back and serve, except that you've already taken action pursuant to the service, or perhaps you disagree with that representation.
Well, Your Honor, what I did is I sent out a letter demanding appraisal on behalf of Castle Key Indemnity pursuant to the terms of the policy. I'm not sure how that is, waiving service on behalf of Castle Key Indemnity.
I don't know.
Yeah.
How was your demand style? Did it have a case style to it, or was it just a letter?
It's just a letter that references the date of the claim and the claim number. That's all.
So not referencing the case number or any of these?
No, it doesn't have a case number, no.
All right.
Listen, I mean, the parties are in appraisal. Your Honor can make her decision. It's just, I mean, I am not authorized to accept service. That's why I cannot agree. I understand. Why can't you just accept, service? I'm not authorized to do that. So if I'm not authorized to do that by Castle Key, I mean, technically they're not a party to this case. How can I bind them to anything in this case when they're not a properly served party? That's where I'm coming from.
Okay. Anything else?
How about this, Your Honor? How about we drop? We do a note. We grant the motion to dismiss. I'll serve Castle Key. I'll drop Castle Key Insurance Company. Leave to amend. I'm going to add Castle Key Indemnity Company with a new summons and serve them as well. And we have my case that's filed. We're in appraisal, and then I'll have the right insurance company in here. I'll serve them with process server, and then when the appraisal's over, we'll deal with the issues of the fees. Just and if I'm not entitled to them, I'm not entitled to them. If I am. We'll figure it out then.
Mr. Best, anything else contrary to that?
No, Your Honor.
Okay. All right, then I think that's fair. I just want to make sure I'm clear, Mr. Bernstein, on what you had said. Your suggestion was court go ahead and grant the motion to dismiss and grant it with leave to amend, or is that really moot because it's going to be a different?
I don't want to file a whole new case and another filing fee. I do believe I can. I can do what I
can grant the motion to dismiss and grant him leave to amend.
And I'm going to add a party and a leave to add another party. And I'm sorry, we could have agreed to this, Your Honor. It's just sometimes it takes a hearing like this to figure it out.
Well, I can appreciate, based on the counsel's back and forth, that potentially it implicates entitlement to fees down the road. I've had a few of these cases, and I understand it can be a delicate dance. So That's what I'll do then. I will grant the motion to dismiss. I will grant leave to amend, and we'll include a directive that plaintiff will need to serve the newly named defendant with fresh service, and then we'll see where that takes us. Is there anything else to further clarify, Mr. Bernstein?
No, Your Honor. Thank you very much.
Mr. Best, anything else?
I don't know if it's really necessary, but there was discovery served on Castle Key Insurance. I guess by granting your motion, you kind of moot that requirement to respond to that discovery.
It's worth clarifying, and I think that's a fair point. I think in light of the fact that we're gonna switch gears and the proper party hasn't been served, we cannot hold that other party liable for not answering discovery yet. So all of those time clocks will start when service is had on the indemnity corporation.
Okay.
And if you want to include a line to that effect, I'll ask you, Mr. Best, to prepare the order, run it
Sure.
by Mr. Bernstein, and then just send it to my office in Word format, and we'll get it right back out to you.
Okay. Thank you very much.
Okay.
All right, thanks, Your Honor.
All right. Thank you both. Stay well.
Bye-bye.
Okay, you too.
All right. That'll bring us to First Technology versus Hirschenroder.
Good morning.
Do I
Yes,
have
Your Honor.
counsel for First Technology?
Yes, Your Honor. Jennifer Scott on behalf of the plaintiff.
Okay, Ms. Scott. And am I saying it correctly? Is it Ms. Hirschenreiter?
Yes.
Okay, good afternoon to you both. This is plaintiff's motion for summary judgment, which we rescheduled briefly at defendant's request for medical need. And so I'm happy to see you here, Ms. Hirschenreiter. We'll invite Ms. Scott to go ahead and proceed now with her motion.
Yes, Your Honor. We filed a complaint for monies due on a credit card in this case. The amount due is $26,635.06. We're also seeking interest, costs, and fees. Our summary judgment and affidavits supporting the amounts we're requesting were filed in December. As you pointed out, this was a continuance of the hearing set earlier this month. And the defendant did file an answer in this case, but it doesn't really raise any defense. It's just a general denial. It's a one-sentence answer. And I do not see that any affidavits in opposition were filed before this hearing. So at this point, we're seeking final judgment for the $26,000 and then $2,245.58 in interest, $468 in costs, and $560 in fees.
Tell me the interest one more time, please.
$2,245.58. Interest is under the agreement is at 10.99%.
And it was right about $8 a day. The last figure was from October 5 at $1162.86. So that sounds to be on track then. Okay, Ms. Hirschenroder, I know I've had you in a couple of cases that have been ongoing. I know it's a difficult time for a lot of folks right now. This is a little bit of a technical procedure. Did you follow what was being said by Ms. Scott, or did you?
Yeah.
Not? Okay.
I did. I have been going through financial hardship due to the pandemic, so I basically lost everything. So I don't have the funds at all. But
Okay.
on top of that, I don't have an attorney, obviously, because of that reason as well. And this particular money, I was working at the time for Naples Auto Supply. My boss borrowed that money from me and never paid it back. And I just really don't know how to go about that situation. It was for a card. Like if they keep the phone records, like that first withdrawal that I took, it says, they asked me what is the money for, and I said for a car because I was working at that car dealership. I don't know how to go about going after him for this. So I just figured I'd bring it up to you. And
Okay. All right. Well, I can address a few things with regard to the person who owes you this money. I can't give you any legal advice, but I would simply say that there's potentially an avenue for you to bring your own lawsuit for that, but it wouldn't have any direct impact on this lawsuit. The documents that were submitted here in support of this suit do name you as the borrower. So I only have you for today's purposes, but whether you turn around and sue someone who owes you is up to you. And I just would encourage you, you may be able to contact lawyer referral at the Collier County Bar Association for a low-cost consultation, or you may qualify for legal aid. Legal aid doesn't usually bring a whole lot of lawsuits, but they may be able to give you some what they call advice and counsel to help you do your own thing. That's as much as I could say about that, just to make sure you know there's some resources in the community for the legal advice that I can't give.
Okay.
For today's purposes, I know you and I had an unrelated matter, but related for you, which is an eviction matter. The law right now is recognizing some protection on evictions for pandemic consequences, but these sorts of things are not currently receiving any sort of special consideration for hardship and so forth. The good news is that compared to your eviction, this is not quite as threatening. This is a judgment that would memorialize that you owe First Technology this money, but we will not come remove you from your home or anything like that over this judgment, the way an eviction judgment works. So in terms of threat, for lack of a better word, this is a lesser threat. I am going to find that First Technology has tagged the bases here. There really isn't any controversy, which is what their motion asks me to decide. Your answer was just general, perfectly fine, but it doesn't really create a controversy that would necessitate a trial in a courtroom and all of that. Essentially, you're admitting you owe it, but you just don't have the money, and that's okay. Was somebody trying to break in? Or it might just be background noise. So what I'm going to do is this. I am going to grant the plaintiff's motion. Did you have something, Ms. Scott?
No.
I'm sorry. You get used to reading faces when you do Zoom and try to make sure that you let people talk. So I'm going to grant the motion. I'm going to find that there is no controversy here, that the money is owed, and I will grant a final judgment with the four amounts: principal, interest, costs, and fees that were spelled out. I'll ask Ms. Scott to forward a proposed final judgment to the court, and you can do that in Word format to my assistant. I've got Ms. Hirschenroder's email, and you'll get a copy of that once I have signed it. You'll get that by email. And then from there, Ms. Hirschenroder, again, I can't give you advice, but I will give just a simple explanation of what's going on. As I said, that judgment is a public document that memorializes that you owe the money. If you come into some money, First Technology can use legal procedures to try to get at least partial payment. Ms. Scott, are you all going to be seeking a fact information sheet?
Yes, we usually do submit that along with the judgment.
Ms. Hirschenroder, that's a financial affidavit, and that's really your opportunity to set forth your current circumstances. You'll do it under oath. We will get that to you, and it will be your obligation to fill it out completely and truthfully. Don't send it back to me. It goes to Ms. Scott's office. It will have your private financial information, and she'll keep that private. But again, that's your chance to say, look, here's what I got. And then Ms. Scott's office will use that information to figure out where to go from here. You are always free, whether it's now or a year from now, if you're back on your feet, you're always free to reach out to Ms. Scott's office and try to work out a payment plan or something. The upside to that, I'm sure it'll money's tight for everybody, but the upside is it gives you some certainty. You can budget, and it gives you predictability. If you don't have any kind of a payment plan, then there are legal procedures that First Technology can use, and they can be a little disruptive in terms of their ability to try to attach things that might help pay at least part of the judgment. So just remember, you always have that ability to try to negotiate. I can't force either side to come together, but I think that it's a fair point for the person in your seat to know you do have that power to pick up the phone at any time, and nothing ventured, nothing gained. If they won't agree to it, fine, but maybe you can make something happen there.
Well, currently I'm unemployed, and so as soon as I get back on my feet, I'd be more than happy to do that, but it's just going to take a little bit more time.
Okay.
So I don't have any income as of right now, but
Okay.
as I said, I was sick for the whole year, so completely out of work.
Okay.
But when things get better, I definitely will work something out with them, because I don't want to be, and I'm going to try to go see if I can get something going to get the money that is owed to me, because I didn't even spend that money. That money was spent by someone else.
Yeah.
So.
Well, good. I think that you're understanding what I'm saying, and I'll grant the judgment. I'll look for Ms. Scott to send that in Word format, and we'll get it back out. Ms. Scott, if you will keep the fact information sheet as a separate attachment, so just the judgment in Word, and then the fact information sheet can be a PDF or whatever you want. But if you'll separate those, because I have to file the judgment without the fact information. But when we send out the signed version, I will take responsibility for ensuring that the fact information sheet attachment is emailed to Ms. Hirschenroder, so she has it.
Okay. Where am I sent? What's the email that I should send this to?
Do you want to state that, Ms. Hirschenroder?
Sure. Graciela, GRACIELLA 1977 at yahoo.com.
Graciela 1977 at Yahoo.
Yes.
And then for you, Your Honor, where am I just uploading it to the division or your assistant?
No, we're not there yet, but I'm told it's any day now. We'll have that. My assistant is A. Shotwell, ASHOTWELL at ca.cjis20.org. A. Shotwell at ca.cjis20.org.
I got it. Thank you, Your Honor.
Okay, and then we'll get that out. Ms. Hirschenroder, just make sure that you pay attention to the fact information sheet and get that turned back in. As long as you get that back to them, not me, you probably won't talk to me again unless there's any kind of an issue. But when things turn around for you, then feel free to reach out to Ms. Scott's office and see if you can get one thing off your plate here.
Sure. Thank you, Your Honor.
Okay, anything else from the plaintiff, Ms. Scott? Oh, you're on mute. I think you're on mute.
Was I muted?
You might have been on mute and had your speaker off because you weren't hearing me say you're on mute.
Oh,
Yes.
okay. I have a couple more hearings with you at 2:30. Do you want me to call back in, or do you want
Totally
me to?
up to you. I'm just going to turn the camera off, so you're welcome to stay on.
Okay. Thank you, Your Honor.
All right, Ms. Hirschenroder, anything else I can clarify for you today?
No, that's it. Thank you.
Okay, well, good luck to both sides, and that'll conclude our hearing. Thanks, everybody.
Thank you.
We'll be in recess until 2:30. Okay, good afternoon again. We're back in session for the 2:30 court session. And Ms. Scott, you're here on behalf of Suncoast, is that correct?
Yes, I have two. Let me.
Kuipers and Burgess.
Correct.
All right. Let's address Kuipers first, please. The summary judgment.
Okay. In this case, is the defendant here or?
No.
No. Okay. Okay. In this case, we sued for money's due on a loan. Actually, it's a car loan deficiency. Initially, we filed for about $11,000 and change, and during the course of the lawsuit, the vehicle was sold, and so we did reduce the amount we're seeking, which we put out in our affidavits. And so at this point, we're seeking $4,058.57 on principal, plus interest in the amount of $877.50, costs of $436, and attorney's fees of $500. The defendant did file an answer but it really was just financial hardship and inability to pay. It didn't appear there's any real defenses in there.
I am inclined to agree. I'll find there's no genuine issue of material fact and would grant summary judgment, would enter a final judgment reflecting the figures that you've just set forth. On this one, I also, it's weird, I also have an eviction with this gentleman, which he referenced in his answer. So I have his email as well. And we can get things around that way because I no longer have a good address. I think you all served him at the address from which he was evicted.
Oh, okay. Okay.
Let me pull that up in the other file and share that with you.
Yeah, we had Coriana Way. That's where he's no longer there. Okay.
I am fairly sure that's the address. This is case 1024. So let me find. It's case 547. Let's see if this is it. Yeah. Kevin Kuipers, same one. You know what? Now let's see. Hold on. That maybe we're calling it because it's his new address. Let me see. Actually, I don't have either one. It was 20th Avenue Southeast.
He was served on September 21st, 2020.
Okay. And I think he might have been out of there. So that address may be fine.
Okay.
Let's see. Yeah, he wasn't evicted until October, but I think he had already gotten out.
Okay.
So I think you're fine. We just see one other. Here. Okay. So yeah, your address may be fine then. I'm remembering it from some other thing. If you want an email, I can share that with you for him.
Yeah, I'll take it. I mean, I can just copy him when I submit the order for this one to you as well.
That's fine. Yeah, it's Custom Kev 31. So custom with a K. KUSTOM KEV 31 at Yahoo. Custom Kev 31 at Yahoo.
Okay.
And so if you want to, you can submit either way. You can either send me the final judgment in Word and just make a notation on the certificate of service that you'll take care of getting him a hard copy of the final judgment, or you can send me a hard copy with stamped and addressed envelopes and we'll take care of getting it out. Either way.
Okay. And so for the last hearing, she has an email of record, or do you?
She does.
Okay.
And I especially emphasize that. I am admittedly fudging the rules a little bit on the emails, but because I'm uncertain how long she's going to be at her address, I've been very dependent on that email.
Okay.
Ms. Hirschenroder?
Yeah. So, did you want us to write into the order that we will serve on him, or
Sure.
write into the judgment that we will serve on him?
That's my preference. Then you can just send me the order in Word, but you've certified that you'll ensure he gets a copy of it.
Okay.
Yeah. So I'll grant summary judgment and we'll execute a final judgment that plaintiff will send in Word format to Ms. Shotwell.
Okay.
Okay. And then the final one is Suncoast versus Burgess.
Yes, and that one is the motion to compel garnishee to remit funds. Now, on this one, judgment was entered back in 2019, and we served the garnishee on December 9th, and they filed an answer on December 13th, 2019, setting forth the amounts that the defendant was paid and indicating they were holding out $138.33 per paycheck, but we haven't received any of those monies. So, and now we've been trying to contact, they're trying to track it down. They have indicated they may no longer be employed, but obviously we would like what they withheld back in December then.
Okay.
So we're just seeking an order, compelling them to remit the funds.
Okay, well, I can give that. Have you had any conversations with anyone, or I mean, we can send orders into the ether all day long. I don't know whether it's going to anyone.
Yeah, well, that's what I was saying based on the notes in the file. It does look like our office reached out, and the defendant may no longer be employed, so we may not get any monies going forward, but they were withholding in December and actually filed an answer to that effect. So we're kind of wondering what happened to those monies.
Sure. Well, I'm happy to grant an order compelling. At some point, somebody's going to have to play a little phone tag and drill down on this thing and see what's up. But if you're representing that you've not been sent any of the funds, I do see their answer and my order. So if my order maybe loosens up the conversation, I'm happy to issue it. If you want to, you can send that also in Word format, and you can, again, just certify that you'll ensure a copy is served on Swissport or mailed to Swissport.
Okay, we'll do that.
Okay.
And that is my last one.
Okay, very well. You're all set then.
Okay, thank you. Have a good day.
You too, Ms. Scott. Thank you. We'll be in recess until 3.